One of the most frequently asked questions we get on our website is, how do I properly prepare for my deposition of my divorce or custody matter in Virginia? Hello, my name is Attorney Van Smith with Smith Strong Law Firm, and we'd be delighted to assist you with your divorce or custody case, and in particular making sure that you have the preparation necessary so that your deposition is strong and solid performance for you and for your family, and frankly, the outcome of your case. So you are wise and intelligent to be searching and getting what you need. But a little word of caution. If you have an attorney and they're not properly preparing you, that's a big red flag. So make sure you're with an attorney and a law firm like ours here at Smith Strong that will take the time to methodically prepare you, not only for the questions they will ask, but what you can expect from the other side. Critically important. But let's go through a few things to keep in mind, best practices, even if you feel like you've been well prepared. All right. The first thing I would consider is, what are your goals for the case? What are the outcomes that you think are optimal? What do you have now? What are the assets? What is the strategy that you have now in place that you're trying to get to? What is the exact summary, if you're in a divorce, of your assets, of your debts? Knowing the home, the mortgage, the bank accounts, the retirement accounts, the investment accounts, the life insurance, making sure you understand where those accounts are, the approximate balance, being roughly familiar with the assets and debts of your family. Next, you want to think about, if custody is at issue, what do you have now as far as the visitation schedule, and what would you like to see, or where do you feel like it could be modified? Next, I want you to think about the incidents in the last 12 or 24 months, conflicts, things that an opposing counsel might zero in on as issues. Were accounts drained? Were there conflicts with children at a drop-off? Being very methodical and preparing your outline of what occurred so you can speak with detail and precision over any incident that's occurred. Keep this in mind. I read a lot of transcripts from divorce matters with cases in our firm, and I'll see ill-prepared opposing parties continue to talk and talk and talk through an answer. If I were to give you one piece of advice, it is to keep your answers crisp, brief, and precise. Don't keep going on and on searching for the answer while you're talking. Have enough presence, have enough confidence, and bearing in yourself to take a breath, take a sip of water, and then speak in a calm, deliberate way, making sure you've thought of what you're about to say before you say it. And when in doubt, say fewer words, say less, and take frequent breaks. Maybe you take a walk out in the parking lot, speak with your attorney to see how it's going and see where we need to modify the approach. But a key point I want to make here is speak with precision, speak with care, and really think about what you're trying to say before you say it. Understand that emotion, that your temperature rising in a cross-examination or rebuttal is the goal of the other side. They're trying to get you off balance. Understand that. A key point in trying to retain control of that battlefield at that conference room table is practice active listening. So they'll ask you a question. Maybe it makes you a little upset. Maybe it's meant to make you upset. One thing is, again, take a breath, take a sip of water, and then practice active listening. Repeat back what you've heard, what you think the question is. So just let me make sure I'm understanding this right. Are you saying at the pickup last week that I slammed the car door after letting the kids out of the car? Is that what you're asking? I just want to make sure I've heard you right. Make sure you've clarified what you've heard, framing the question to one item. If they've asked multiple things that in answering you're assuming as true the thing before it, get them to clarify and reframe the question so that there is only one response, one answer for each question. If they're asking multiple things, refine it and go, I want to make sure I'm understanding the question, and can we break it into parts? This is also where skilled counsel will object and interject and make sure that they're not asking you compound questions that can trick you, that can throw you off, or get you to assume as true things that really aren't part of the record or shouldn't be part of the record. Having skilled counsel that's present, that's prepared themselves is key. You might think that's obvious, but in my experience, it's not. The legal profession as a whole, as I see it, can be a little raw, a little numb. And so one of the keys to your preparation is making sure your attorney is prepared. At Smith Strong, I really don't think that's a problem for our clients, but I see it across the industry with other counsel. And so one of the keys, I believe, in helping prepare for your deposition is having case prep meetings of an hour and a half in length by Zoom or in person with your attorney, at least 2, maybe 3, prior to the deposition. That way, you can rehearse your answers, understand the summaries, understand the landmines, get clear the precise, clear answers you wish to deliver, so that you remain in control of that conference room table at that deposition. I hope this is helpful. And if you have other questions, please message us on this site at smithstrong.com. And I look forward to helping you prepare for your deposition and ultimately your divorce or custody matter in Virginia with me or one of our skilled attorneys here at the firm. Thank you for giving this time.